I apologize for that. All right, let's get started this morning. First of all, any questions that anybody has about anything we've done so far? No questions. Anybody have anything they want to share? Miss Bradford, do you have a question or a share? All right, what's your question? Great question. No, they will go live at 11 a.m. today. And the reason they're not live yet is I just want you to wait until after class because a lot of what we talk about in class is on the assignments. I don't want anybody doing it during class. So that's the reason for that. Since you asked that, let's talk about the two assignments you have that are due Monday night. One is assignment 1.1. It'll pop up here about 15 minutes after class ends. It is 4 questions on rules of my class. It's designed for you to make 100 on. You can take it as many times as you need to. Hopefully nobody have to take it more than once, but I mean, you know, stuff happens. But the questions on there are, how many absences are you allowed in this class? What's that? 4. Is cheating allowed in this class? Absolutely not. What happens if you do cheat? You fail. Man, y'all are this, so you're going to make 100. And then if you need an accommodation with a deadline, like I'm going to be, Ben, we're out of town for a tournament. I'm gone, or I've got a knee replacement scheduled. Somebody told me they've got that. When is the time to get with me on that? Beforehand. That's right. Good. All right. So that's assignment 1.1. That should take you all of 3 minutes to do, and you should start off the semester with a 100 on that. Assignment 1.2 is 20 questions, multiple choice, and it covers the Brown versus Board of Education case and the Bill of Rights. And we're going to talk today during class. All the answers for the questions that I ask you on that assignment we're going over today in class. Now, I'm not pointing out to you that, hey, this is specifically the question on there, but everything that's on there we're going to talk about. So pay attention today and take good notes. You'll do very, very well on the quiz. Again, those are due Monday night at 11:59. You had a discussion question that was due this past Monday. That was just introduction. If you haven't done that yet, you can still do it. I do read those every week. But the discussion questions I have a little more leeway on. I don't look at them for purposes of your grade until the end of the semester. I go back and just make sure that you answered every question. So that doesn't mean I don't have to worry about any discussion until the end of the semester. It just means if for some reason you forgot or you just didn't have time this week, you can do it later. Yes, sir, Mr. Rose. Yes. You only get 1 attempt on the rest of them. Yeah, the unlimited attempts is for assignment 1.1. That's the only time I do that. The 1.2 is limited and it is timed. But I try to put enough time on there that there's no way you could run out. I mean, there's a way you could run out, but I don't want time to be an issue for you. Good question. So as you get used to the way I have this course set up, if you got questions about how that works, please ask me now. You do have another discussion question for this week that's due Monday. It's really easy. It is your chance to ask me a question about anything having to do with the law. You have a burning question you've always wanted to ask a lawyer, but never had the chance to. I like to collect those at the beginning of the semester, and then as we go, usually at the beginning of future classes, I'll address questions here and there. Stuff people ask are, is law school hard? What is your day like in terms of going to court? Like, how's your day structured? How do lawyers represent somebody that they know is guilty? I mean, it can be anything. Those are just some common stuff that I get. But all I'm looking for is that you ask a question. Just whatever question you want to ask. Easy points. All right. Today, I'm going to finish lecturing. I've got just a little bit left that I want to tell you about alternative dispute resolution. And then I'm going to go over some of the things that I assigned you to read this morning and some of the things that I posted that illustrate things we've talked about so far. So alternative dispute resolution, what is that? Alternative dispute resolution is a way that court cases get resolved without actually going all the way to trial. Now, why would we want to do that? A lot of reasons. Going to trial is expensive. You got to pay a lawyer. You don't have to have a lawyer, but most people have a lawyer. It's time consuming. It is in more complex cases in civil litigation and in criminal cases too. It might be a year or two before you actually get to trial. So your resolution is somewhere down the road if you're going to litigate and let the court case run its course. So alternative dispute resolution arose as a way for parties to resolve their cases quicker than going through the trial process. There's other advantages besides just time as well. I'm going to talk about that here. So I want you to know about 3 specific different types of ADR. One is negotiation. There is nothing that prevents the lawyers or the parties to a case from talking to each other and trying to negotiate their own settlement. There's nothing that prevents that. So just because I sue somebody or I get sued, that doesn't mean that I'm locked in to having to wait till I go to trial and see a judge or a jury to get my case resolved. I can always pick up the phone, write an email, write a letter to the other lawyer with an offer of settlement. Hey, here's what we're looking for. And maybe by just discussing it, negotiation, we can settle our case. That'd be great. We resolve it. We don't have to go through the court and the expense and the time and the hassle and all that. And we both settled it in a way that we're satisfied with. Negotiation. That can happen from the moment a lawsuit is filed up until right before a judge or the jury gives a decision in the case. Sometimes you'll settle cases during trial. I might go to trial and find out something really bad about my client or my case during trial that I didn't know. And that might change our whole outlook on whether or not we want to settle the case. Conversely, something might happen at trial that's really good for me, and my leverage is now increased, and I'm less interested in settling. People's calculations change as the circumstances do. So you can negotiate anytime. Another form of alternative dispute resolution is mediation. Mediation is required by almost all courts now. You've got to try mediation before you can go to trial. Mediation is a process where the parties come together. I say that makes me sound like a dinosaur. We started doing mediation on Zoom 2 years ago, and lo and behold, people found that they really liked that better. So they come together virtually or in person, and there is a neutral mediator who is in charge of the proceeding. It's a person who is selected by the parties or appointed by the court, and the mediator doesn't know anything about the case. The mediator doesn't know any of the people. The mediator has no interest in the outcome. And a mediator makes no decisions, no rulings. So you might ask, well, what's the point? The mediator's job is to go back and forth between the rooms if the parties are present in person, or virtually if they're on Zoom, and try to see if they can get the case settled. So what does that look like? Let's say it's a car wreck case, and I sustain injuries in a car accident. We go to mediation, and I ask for, I want $1 million. I tell the mediator, here's what I want on $1 million. Here's why I want the $1 million. And the mediator goes to the other room, and he comes back with their counteroffer. I mean, I guess, they could always say yes to the first offer, but I've been mediating for 15 years. I don't think I've ever had anybody say yes to the first offer. If it was that easy, we wouldn't be in court, right? Or we wouldn't be in a lawsuit. So the mediator will go back and forth and exchange offers and help the parties narrow down the issues that they have in contest. So the mediator, a good mediator, will not just be a messenger, like, messenger pigeon, here's our offer, send it to the next room, and then the pigeon's just going to bring it back. A good mediator will talk through the case when they're in the private meetings with the parties and lawyers, find out not just what their offer is, but why that's their offer, find out the reasons behind it. And very often a mediator, by doing that, can either help a party see where they might have a weakness in a case, or whether they might be asking for something that's not reasonable, or they just might gather information that helps them, because the mediator, remember, is listening to both sides. The mediator knows what each side wants as a bottom line. The mediator doesn't tell the other side that. That's confidential. But the mediator might know, well, they've told me confidentially that they're asking for $1 million, but they'll settle for something around $500,000. And the other side might say, well, there's no way in hell we're paying $1 million, but we would probably pay around $500,000. If the mediator knows that, then the mediator can keep moving them forward to get them to that point. Conversely, if the mediator has met with everybody and has gone back and forth a couple of times, and one side says, there is no way in hell we're accepting a penny less than $1 million, and the other side says there's no way in hell that we'll ever pay more than $500,000, then the mediator can tell the parties, thanks for being here. You're not going to settle your case today. Congratulations. It's a great opportunity for the parties to go, and it's really the first time in a case when you find out exactly what the other person's asking for. They kind of got to put their cards on the table at that point. So once you get an offer, you're like, okay, well, if that's what it'll take to settle the case, let me think about this. I could pay $500,000. The case would be over. I wouldn't have to pay the lawyers anymore. I would know for sure what my exposure is, and we'd be done with it. Am I willing to do that? Or I'm going to take my chances. I know I got to keep paying a lawyer. I know that the judge or the jury could award more than $500,000. And you can weigh your risks. So mediation affords the parties a chance to really analyze the cost and benefits of keeping their case alive, of going all the way to trial. Mediation results in settlement of more than 50% of cases. That's not official. I think the statistics would back that up easily. But I know that in 15 years of being a mediator, more than 50% of the cases that I mediate end up settling. So it's a very beneficial in that regard. The other great benefit about mediation is that if you settle the case at mediation, you have control over it. You've agreed to a settlement because you are okay with what the resolution is. So I'm going to take it back to the divorce arena again. If I'm mediating a divorce case and we are talking about visitation with our children, who gets Christmas, who gets Thanksgiving, how many weeks in the summer, how many nights a week they spend at mom's house, how many nights a week they spend at other parents' house. If I'm negotiating that in mediation, if we're mediating that and we come to an agreement, then that's something that I can live with. I might not be happy with it, but at least I can live with it. Say my family's traditions are that we celebrate Christmas on Christmas Eve. Well, at mediation, I could make sure that I get Christmas Eve. I might have to give up Christmas morning, but I'm in control of that. Contrast that with going to court, where I'm going to tell the judge what I want, my wife's going to tell the judge what she wants, and the judge is going to decide how we're going to split up visiting with our kids. And that might not be good with either one of us. He or she might give my wife every Christmas Eve, and me every Christmas morning, and that screws up our whole family Christmas traditions. So at mediation, we've got the power to say yes or no over that. That's another reason that mediation is really, really good. Once you go to the judge or the jury, I mean, it's in the judge or jury's hands. And we might both walk away not liking what they say. So it's always a cost-benefit analysis. Here's what I could settle for, and is that worth it risking a better outcome, but also risking a worse outcome? That's mediation. If you mediate a case and you don't settle, then everything that happens at mediation is confidential. So you can't go to trial and say, well, at mediation, they offered to let me have every single Christmas. Can't do that. So that protects your ability to negotiate a mediation without worrying about that being used against you later on. That's another benefit of mediation, is everything that happens there is confidential. Very often, I would say, of the cases that don't settle at mediation, they settle later on based on the groundwork that you laid at mediation. So we might not have settled the case because we had 10 issues and we agreed on 9 of them, but we were still far apart on alimony or child support. But that doesn't mean that after mediation, the lawyers can't pick up the phone and continue negotiating and over that one issue that they're still outstanding on. Now, it doesn't mean that we're bound by the 9 we agreed on. We didn't settle the whole case, then nothing's settled. But very often, people will leave mediation and things will change in a way that they're like, you know what, that was important to me at mediation, but that is really not that important to me now. I'm just ready to be done. So let's negotiate some more. So mediation is helpful, even if you don't settle it at the mediation. It's helpful because it really does help narrow down the issues, and it helps you understand kind of what the other side's position on each issue is, which up to that point you might not know. All right, so that's negotiation and mediation. The third ADR method I want you to be familiar with is arbitration. Arbitration is also outside of a courtroom. You have a neutral party like the mediator. This time it's called an arbitrator. And the main difference between mediation and arbitration is that the arbitrator is going to make a decision. The arbitrator is going to rule one way or another on what happens, who wins, who loses, who pays what. And the parties are bound by that decision. Courts do force you to go to mediation because that helps resolve cases without clogging up their calendar. But they don't force you to go to arbitration. You have the right to take your case to court, to trial, if you want to. Why do people choose arbitration then? Good question. Arbitration is great for cases that need a quick resolution. Say I don't have 2 or 3 years to wait to get to trial on the case. We need to get this resolved now. Let's pick an arbitrator. Let's enter into an agreement to arbitrate the case. Let's let the arbitrator make a decision. An arbitration is like a mini trial, a less formal trial. You do have witnesses testify. You do present evidence just like you would in a courtroom. It's just done in a more informal setting. We do it a lot of times in a conference room. Yes, sir. Judge Judy is, so that's a good question is this like what Judge Judy does? Kinda. The people that go before those TV judges, they agree that they're going to do that instead of going to court. So she is really kind of doing an arbitration. She's loosely following the rules of procedure, but she's not as bound by them as she would be if you were in a formal court setting. So that's it. So it's not unlike that. It is unlike that in that you don't have a judge just kind of doing whatever they want to do, like Judge Judy and Judge Brown and all those folks do. They're really more bound to follow the laws. And it's really more in a conference room, or it's in a less formal setting than that. But not unlike that. Yeah, you might choose, instead of waiting this out to go through the court system, we're going to choose to arbitrate, and we're going to let this neutral party, be it a judge, or it doesn't have to be a judge. Now in Georgia, it has to be somebody that's certified. It can't just be like, I can't, pick Mr. Nass to arbitrate my case unless he's a certified arbitrator, which he may be. Yes, sir. No, those two, and the question is, what about the TV judges? I think that the parties in those cases agree to go on TV and have this judge resolve their dispute, and they agree. They enter into a contract that says we will agree to be bound by whatever the judge decides. So they're not. Nobody's there against their will. But if you do that, you're saying, okay, yeah, I'm giving up my right to do that. And you're doing that by entering into a contract with the other person and with the TV folks. That's how you're going to resolve it. Yes, sir. Mediators, so good question. Do they have to be official? Yes and no. If the court orders you to go to mediation, then you've got to use a mediator who's certified by the state. But let's say that I file a lawsuit against you and we haven't been ordered to mediation yet. There's nothing stopping me and you from picking Mr. Nass to mediate our case. I mean, we could ask him to if we wanted to. We're not bound at mediation. You're not bound to resolve your case. So I could say, hey, let's go try to mediate this informally with Mr. Nass, and we could get in different rooms. He could go back and forth. And if we come to an agreement, then you put that in writing and you'd be bound by it. But if we don't come to an agreement, then we tried, So yes and no. The benefit of having trained mediators is that they're trained in mediation. They know the tricks and the way it works. And if you have a mediator that has a lot of experience in the area that your dispute is in, then that helps a lot, because the mediator, even though the mediator isn't going to make a decision, the mediator can still say things like, I've been doing this for 15 years. I'm not sure I've ever seen a court award $10 million on this type of case. Or have you thought through, what is your expectation about how the court would handle this? Or how do you think a judge would react to this or that? And you're sort of reality testing with the people, and the goal is to hopefully get them to see either strengths or weaknesses in their case, and to get more realistic about what is actually going to happen at trial. So that is one benefit of having a mediator. I don't mediate anymore, but I did for 15 years, and I quit because I just got kind of burned out on it, and I lost my ability to kind of empathize with the parties, and I just got tired of hearing it. And I was mediating a lot of divorce cases, which will tend to burn you out after a while. But I didn't have any problem looking the parties in the eye and saying, look, none of us can predict what Judge McBride is going to do, but your case is assigned to Judge McBride. I've been practicing in front of Judge McBride for 15 years. I've never seen Judge McBride allow a person to have 5 girlfriends live in the apartment with the kids. If you think that Judge McBride's going to allow that, you need to think really hard about whether or not that's realistic. If that's what you want. I made that up, obviously, but I can't predict for sure what a judge is going to do, but I can give my experience with a certain judge, and this is the way they handle things, or with courts in general. So that is the benefit of having a good mediator. Yes, ma'am. Yeah, so great question. The question is, can you appeal from an arbitration? The answer is yes. So even though you're bound by the results of the arbitration, you do have recourse if you don't like what happened. You can appeal that to an actual court. The difference, the trick about arbitration is that it is really, the grounds for overturning an arbitrator's award is what their decision is called, have to be something like fraud. Whereas in just general appeals from a court, if the court did something wrong, you can get that overturned. In an arbitration, it's very, very difficult to get the award overturned. So that's a great question. Yes, you can appeal, but it's very hard to be successful. So why else might I want to arbitrate a case other than just getting it over with? Well, I might have a really complex case that involves construction law and really complex engineering evidence about why something wasn't constructed correctly. And I might rather choose an arbitrator who's an expert in this particular area of engineering or construction law, or an arbitrator who hears nothing but construction law cases. I might much rather have that person decide my case than a judge or a jury who may not be familiar in any way with something this complex. So the parties have to agree to go to arbitration. But I might much rather go to arbitration and have somebody who knows what they're talking about decide my case rather than leave it up to the fate of a jury of my peers when it comes to something like that. In the commercial area, I want you to pay attention to this. Lots of contracts that you enter into, leases or form a contract, lots of those agreements that you click through on the internet, where we click the I agree box, but we never read anything. A lot of contracts have mandatory arbitration clauses that say, I agree that if a dispute arises out of this contract or out of whatever relationship it is that we're establishing by contract, that we're going to arbitrate the dispute instead of going to court. So you might be giving up your right to go to court if you enter into a contract that has an arbitration clause. So always be very, very cognizant of that. That might be beneficial to you. You might be like, that's great. I'm glad there's an arbitration clause in here. I don't like them because I want my choice. I always want my choice. I just can't know now whether or not I'd rather arbitrate or go to court. I just don't want to I don't want to have an opportunity foreclosed on me from the beginning. Typically, the people who put arbitration clauses in contracts put them there because it's favorable for them to do so, or they wouldn't have put it in there. So who does that? So think about like big companies where it would be easier and cheaper for them to just resolve all their commercial consumer disputes by arbitration rather than having all these things turn into lawsuits that then turn into discovery, that then turn into paying lawyers, that then last forever and ever. They might much rather just resolve it through arbitration. It's cheaper for the company. Companies might also rather have a neutral, well, judge would be neutral too, might rather have a non-jury decide their fate, where emotion doesn't come into it. Whereas a jury might not know anything about construction law, and the jury might be outraged at conduct and award some huge, jury verdict, whereas an arbitrator who hears this day in and day out may be desensitized from that, may look through the emotion and just make a decision based on, the damages or the economics of it. So some companies who put those clauses in, they do so because they would rather just go to an arbitrator than leave it up to risk going to a jury. But that's not to say that if you are looking at a contract that has an arbitration clause in it that it's bad for you. That's not to say that at all. It's just to say that you should be aware that if you sign that contract, you are giving up your right to do anything but go to arbitration first. All right, any questions on alternative dispute resolution? Used to be that lawyers have always negotiated since the beginning of time, but mediation and arbitration that's new within the last 30 or 40 years, I would say. And it used to be, when it first came on, it was not widely used. And today it is, mediation is required by almost every court. So alternative dispute resolution is very, very common. Mr. Rose. I don't know, but for the question is, if mediation settles the majority of cases, how many go to arbitration? In my experience, arbitration is much less common than mediation, if for no other reason that mediation is required. A lot of folks just don't know about arbitration, or they don't want to. And you have to pay the arbitrator, so that's another cost you wouldn't have if you go to court. You don't have to pay the judge, but you do have to pay lawyers to continue your case. I would say arbitration is more and more common, but not near as common as mediation. And then you couldn't really compare success rates, because arbitration, they're going to make a decision. I mean, you're 100% going to get a decision made at arbitration, whereas at mediation, you may not settle the case. Yes, sir. Follow up.
Is arbitration official? Like you have a judge of the state, you have arbitrators of the state?
So arbitrators, the question is, how official are they? Arbitrators have to be licensed and certified in Georgia by the state of Georgia. So you have to go through training, a certain amount of training, and you have to do some practice stuff, and then you got to get certified and re-upped every year. And then so if you're looking for an arbitrator and you didn't know where to look, you could go to the Office of Dispute Resolution that the state of Georgia maintains, and they got a list of arbitrators. And they'll break it down by specialty and things like that. So if I'm looking for a specific, topic that I need an arbitrator with an area of expertise in, I could do that. Yes, sir. The question is, the case filed the same way. Parties have the opportunity to elect arbitration if their case is already going. But if you've signed a contract that says we're mandatory arbitration, the lawsuit may not ever be filed. You're just dealing with the arbitrator. You're not on a dual track with arbitration in the court system. You could be, but you don't have to be. Does that answer your question? All right. Any other questions? All right. That's ADR. In your content section, I'm not going to pull it up, but I posted a little chart that compares ADR methods. So if you're interested in doing a deep dive into mediation, or you're not clear on it and you like charts and you're a visual learner, it's a really small chart. It's a good thing to look up. All right, the rest of the class today, I want to explain to you and give you some examples of stuff that I've lectured on so far. Oh, I thought I already did that. All right, this is the Georgia State Court System. If you can't see that up here, you pull it up on your Cougar View. So you recall that we talked about how there's a federal court system for the United States. I'm going to get to that in a minute. And then each state has their own court system set up however they want it. It's hard to compare apples to apples because the names of the courts within each state court system differ. It's not uniform across states. And the way that they set up their system, the way they decide which court handles which types of cases, that's just a state-by-state basis. I think that's super confusing. For example, if you're a Law and Order fan, their trial courts are called Superior Court. So when they click on their little slides and they're like Supreme Court Part 51, and it's a trial, that Supreme Court in most other places is the highest court of that state, and it's an appellate court. It's not a trial court, but they don't do that in New York. So I just say that to illustrate to you it's different from state to state. I'm not testing you on anything on this slide, so everybody can just relax and just listen. This is for illustrative purposes. I just want you to see how a state court system is set up. And the takeaway from this is that every state's going to be different. And the way that each state has set up which court you go to, and then where you go to after that court and how you appeal, that's going to be different from each state. Generally speaking, all states are going to have a level of trial courts. For Georgia is going to be these 7 down here. This is your entry point into the state court system. We talked about jurisdiction, personal jurisdiction. If your dispute involves something that happened in Georgia, or you live in Georgia, or you're suing somebody in Georgia, Georgia would have personal jurisdiction over the parties. But then subject matter jurisdiction determines which court you go to depending on what the subject matter of your case is. Juvenile court is for crimes involving minors. In Georgia, that's people under the age of 18. It is also the court where foster care and children that are removed from their parents, all that's held in juvenile court. So if I had a divorce situation, or I had a will, and my brother and I are fighting over our mother's estate, we can't go to juvenile court. There's no subject matter jurisdiction there. The court for wills and estates and guardianships is probate court. In Georgia, probate court also is where you go to get your marriage license and your gun permit, which I've always thought is an interesting combination. So one-stop shop to get married, but also get armed. So take away from that whatever you will. Just as an example of how states do it differently, in Alabama, adoptions go through probate court. I have no idea why. In Georgia, they're not in probate court. You got to go to a different court. Magistrate court and municipal court, these are like your small claims court, like your people's court, like your, they have limits on your amount in controversy. So if it's less than $15,000, you can go to these courts. Maybe I hired somebody to build a deck on my house for $10,000. We signed a contract. I paid the $10,000 and the work was never done. I might go to magistrate court to sue that person. Magistrate court is a lot faster than some of the other courts. And so you don't have to have a lawyer in any court. But magistrate court, a lot of people go there without lawyers. Hudson. Question is, can judges travel between the courts? They do not. So your juvenile court judge just does juvenile court. Your probate judge just does probate court. That's Georgia. I think that's probably generally speaking the way it works everywhere, but that's a great question. Recorder's court is in Georgia kind of your first stop if you get arrested. If you got arrested and put in jail, your next stop would be recorder's court the next morning to see if you get bond, set your bail amount or not. It's kind of the preliminary step in the criminal system. These are your trial courts. State court and superior court are your courts in Georgia, they're your courts of general jurisdiction. That's the courts that are not as specialized as like juvenile court or probate court. You can file pretty much anything in superior court or state court. So you're going to have the most variety of cases in those courts. It drives me crazy that they have a court in the state court system called state court. Like that just confuses the hell out of everybody. But that's just one of the different courts we have. It doesn't mean that the rest of them aren't courts of the state of Georgia. They are. That one's just called state court. Georgia has 159 or 169 counties, something like that. And in almost every county, you'll have one of each of these 7 courts. Some of the smaller counties don't have state courts, and some of the smaller counties wouldn't have a municipal court. But every county has a superior court. Every county has a probate court. Every county has a juvenile court. Everybody has a magistrate court. And that's where you would go. That's how you determine which court you go to if you live in that county, or that's where you sued the person, or that's where the event that's in controversy happened. These are our trial courts. The top 2 are our appellate courts in Georgia. Georgia Court of Appeals would be your first stop after your trial court level. If you didn't like what happened to you at trial court, your first appeal would almost always go to the Georgia Court of Appeals. Sometimes you skip the Court of Appeals and go to the Supreme Court. You don't need to know the distinction between that. Most of the time, your first stop is here to the Georgia Court of Appeals. And if you don't like what happened there, then your next stop is the Georgia Supreme Court. Now, remember I told you on Tuesday, some cases don't stop at the Georgia Supreme Court. If it involves the Constitution or a federal law, then you might can skip over to the federal court system after you've reached the top of this one. But it's not automatic. It just depends on what type of case you have. You'll also see that in Georgia, our superior court, which is a trial court, which is a court of general jurisdiction, is also an appeals court for recorder's court, probate court, and these 2 courts. So if you don't like what happened to you in these 4 places, before you got to the Court of Appeals, you'd go here. So the superior court is a trial court, and it's also an appellate court. Just depends. The illustration, again, I'm not testing you on any of that. Just need you to know that every state sets it up differently, and where you start out and then where you go next is just going to depend on the way that that state has it set up. That's how Georgia works. Any questions on Georgia? All right, here's how the federal court system is set up. A little more simplified. Your entry-level courts in the federal court system are your district courts. It's your trial courts where you begin your case. The equivalent of this in the state court system would be those 7 courts that we looked at. Your trial happens here. You don't like what happened there, your next appeal is to the United States Circuit Court of Appeal, and then you would go up to the Supreme Court of the United States. Remember, the Supreme Court of the United States doesn't have to take your case. After this step, you're guaranteed to go this step, but you're not guaranteed to get another appeal. They got to give you permission. The way that the United States court system is set up is that the country's broken down into different districts according to population. So in Georgia, we have 3 districts: northern, middle, and southern. The lines are drawn crazy. It's not as simple as you would think. They would just draw straight lines across the state. But Columbus is in the middle district of Georgia with Macon. Athens is actually in the middle district of Georgia. And then kind of north of here, Atlanta, that's northern district, and then south of here would be southern district. So that's how that works. And then the courts of appeal for the United States, they would cover, they're divided into circuits that comprise several states. So if I went to trial in the middle district of Georgia and I wanted to appeal, I would appeal to the circuit that Georgia's in. We're in the 11th circuit, and that's with us in Florida, and I think just us in Florida, maybe Alabama too. But that's how that goes, just divided up for ease of, where you go, where your next level is, so that you're not going to get assigned to some. If I appeal from my case in the middle district of Georgia, I'm not all of a sudden going to have to go to an appellate court in California. I mean, there's a system to it. So that's how the federal court system works. Any questions on that? All right. I also put up examples for you if you wanted to see what a statute looks like. Remember, that's a law passed by a legislative body. I've got some code sections from the Americans with Disabilities Act. If you just wanted to look at it, you're not tested on it. I also put up an example of administrative law. You remember those are rules that are made by administrative agencies at the state and federal level. The example that I put for you is the hunting rules made by the Georgia Department of Natural Resources. And that is an administrative agency of the state. They make the rules for hunting seasons and limits and that sort of thing. That's law. It's not in the Georgia Constitution. It wasn't passed by the Georgia legislature. It wasn't decided by a court. It's not case law, but it's still law as it's a rule made by an administrative agency. That's just an example if you're interested in looking at that. I would like to move next to the Bill of Rights. Go very quickly over this. Your assignment does contain questions on the Bill of Rights, and I'm going to give you some examples in a minute. Well, let's just talk. We didn't talk about this Tuesday in depth, did we? All right, y'all have to remind me. I'm trying to take good notes, and I'm generally teaching the same thing to you that I am at 8 o'clock, but sometimes I might tell them something in a different way that I tell y'all. So if I get into something and you're like, well, you've already told us this, please stop me. I don't want to subject you to having to listen to the same boring lecture twice. I didn't get into this with y'all, and I did with them, so I was just making sure. All right, the Bill of Rights, first 10 amendments to the Constitution. This should be a review for you from high school civics. I just want you to know generally what each amendment deals with. So First Amendment, we're familiar with this. This is the amendment that guarantees us the right to freedom of speech, freedom to assemble, freedom of religion, First Amendment issues. Second Amendment gets a lot of publicity. That's the right to bear arms. So any restrictions on gun control, those implicate the Second Amendment. Second Amendment issues. We don't talk about the housing of soldiers anymore in the Third Amendment. That is not a modern thing. So don't worry about that. The Fourth Amendment is important because the Fourth Amendment guarantees us the right to not have our property, ourselves, our homes searched unreasonably. So the Fourth Amendment protects us against unreasonable searches and seizures, meaning the government can't just come search our persons, our property, our houses, our cars, our offices, our land without probable cause. So the Fourth Amendment is all about unreasonable searches and seizures. We'll get into that a little bit more when we get into criminal law. The Fifth Amendment you'll be familiar with. This is when people say, I plead the Fifth, or I take the Fifth. The Fifth Amendment guarantees you that you don't have to testify against yourself. You don't have to give law enforcement any information that might incriminate yourself. If I'm at trial, if I'm being tried for murder, they cannot force me to testify. And even if I do testify, I could still refuse to answer questions if answering those questions would incriminate me. That's Fifth Amendment. Fifth Amendment also is the protection against double jeopardy. You can't be tried for the same crime twice. So if you go all the way through a criminal trial and you're found not guilty of whatever it is you were charged with, they can't turn around and charge you with it again and try you again with it. Doesn't mean that they can't try you for something different involving the same conduct if they could come up with something different. But you can't be charged with the same thing and tried the same thing twice. Sixth Amendment, that is the right to cross-examine witnesses against you. If somebody's going to testify against you, And you have the right to ask those persons questions about their testimony. Sixth Amendment guarantees you the right to a lawyer in a criminal case. There is no right to a lawyer in a civil case. If you're charged with a crime and you cannot afford an attorney, they will appoint one for you. That is not the case in civil cases. Your Sixth Amendment also guarantees you the right to a speedy trial. This means they just can't charge you with a crime and then hold you in jail for 10 years without actually taking you to trial on it. Seventh Amendment is the right to a jury trial. The Eighth Amendment prohibits excessive fines or cruel and unusual punishment. And then you don't need to worry about 9 and 10. So really fast, because I want to get to Brown versus Board of Education. These are the types of questions that will be on your assignment having to do with the Bill of Rights. The police search Elvin's locker at school without his permission. Whether the police had probable cause to search Elvin's school locker without his permission is an issue that implicates which amendment of the Bill of Rights? Fourth, good. So we're not getting deep into it. You just need to identify which one it is. Fran was found not guilty of murdering George. The next day, she bragged to the newspaper that she did it. The state of Georgia arrests her again and charges her with George's murder. Is this constitutional? No. Under what amendment? Fifth, good. Harriet was found guilty of running a stop sign, and she was fined $20 million by the judge. She believes that this violates her rights under which amendment in the Bill of Rights? Eighth. That's right, excessive fines. Ivan is charged with arson. He cannot afford an attorney. He asked the court to provide one for him. Which amendment of the Bill of Rights supports this request? Sixth, right to counsel. James is concerned about a proposed new law that bans private ownership of shotguns. Do I even have to finish the question? Second Amendment, right. Which amendment of the Bill of Rights would cover whether Kate has the right to paint an obscene word in giant letters on her roof? First Amendment. Right. All right, good. Those are the types of questions you'll be, and nothing more difficult than those. That's an example of the kind we have. Hudson. Yes. So that's where we are now. That brings us to Brown versus Board of Education. All right, we got roughly 20 minutes left for Brown. Just out of curiosity, now that we've gone over the state court system and the federal court system, which court system is the Brown versus Board of Education case in? Federal. Who said that? Good. Excellent. It's in the federal court system. How do we know that? Because it's the names of the courts were the United States Court of Appeals and the United States Supreme Court. Very good. So this started out in a district court in Kansas. So at the trial court level, when this case began, who was the plaintiff and who was the defendant? Somebody raise your hand, or else I'll start calling. Come on, Mr. Cherry. Who was the plaintiff?
The plaintiff.
Who brought the lawsuit originally?
This is for Brown.
For Brown, yep.
Brown.
Brown did. Who was Brown?
Brown was, I believe, the parent of one of the kids.
That's right. Brown was the parent of one of the kids. The plaintiffs were actually the parents of all the kids, but instead of having a case title with every parent's name in it, they just shortened it to Brown. That's what you're going to say, Alex, right? All right, who's the defendant? I'll let you answer that one. Board of Education, that's right. Board of Education of Topeka. Excellent. So who won at the trial court level? Board of Education won at the trial court level, right. Why did the trial court rule in favor of the Board of Education? What reason did they give for that? Daniel?
The 1879 law that allowed separate.
All right, what was the name of that case? Plessy versus Ferguson, that's right. So the district court said, the district court actually wrote some language saying we really don't believe in separate but equal, but we've got this case that's precedent that we're bound to follow, and we think it applies in this case. So, because in previous cases, the separate but equal doctrine was found to be constitutional, we're going to rule in favor of the Board of Education of Topeka. So, the plaintiffs in the case who lost at the trial court level obviously appealed. What you read doesn't get into it. They did make a stop at the Circuit Court of Appeals. And then after that decision, they made their way to the Supreme Court. So did the Supreme Court have to hear this case? No, but they did. They did state in the case why they decided to hear it. Anybody pick up on that? What was it about the case that they said why they heard it? Right, it did. Yeah, that's a good point. It combined this case with 4 other cases that were percolating up through the court system that involved the same thing. So it just said, this is the same issue. We're going to just combine it all into one case. But they gave a reason why these cases they wanted to hear. Yes, ma'am. Yeah, that's a good reason. That's one. She said it directly challenged, and I'm repeating this from the people watching on video. It directly challenged precedent. Courts do like to, the Supreme Court, higher appellate courts, they do like to take cases that involve direct challenges to things. I mean, if there's something that they feel needs to be decided, like they'll take that case. But they also said in the opinion that this was an issue of great national importance that they felt like they needed to weigh in on. So they took the case. If you had to summarize what the issue is in Brown versus Board of Education, that is, what is it that the court was asked to decide? What is the question before the court in one sentence? Who wants to give that a shot? Awesome. All right. You're getting there. That's close. You're warm. Who can state it more succinctly? More to the point. Come on, let's keep trying. Yes, ma'am. Can separate ever be equal? That's part of it. That's part of it. You're getting warmer. Come on. That is more succinct, yeah, but the issue is kind of broader. You're so close. You're so close. So, what law is at issue? What is the law that Congress is deciding whether it controls in this case? The 14th Amendment to the Constitution. So, if I'm stating the issue, I'm going to say the question before the court is, does the separate but equal doctrine violate the 14th Amendment to the Constitution as it relates to public education? That's the question. And everything that you all said is right. It's part of the question. But if I had to summarize the exact question that the court has to decide is separate but equal constitutional? That's the question before the court. So, who won at the Supreme Court level? Brown did. That's right, Trace. Why did Brown win at the Supreme Court level? The court gave a lot of reasons why they won it at the Supreme Court level. And the court, whereas the lower courts had said they were bound by precedent, the Supreme Court in Brown said, you know what? We're going to depart from precedent. We're going to overturn precedent. That's no longer the law. So when a court does that, they've got to articulate a justification for why they're changing the law. Why are we going against previous cases that were ruled in a different way. This court gives a whole bunch of reasons why. So yes, ma'am, give me a reason. Right. What she said was, there's no way to make separate education equal. You can have the same building, you can have the same curriculum, but in the area of public education, there is no way to make separate equal. That was one reason that they used. Yes, sir.
According to the footnotes, the segregation of white and colored children in public schools has a detrimental effect on colored children. The impact is greater when it has the sanction of the law. The policy of separating races is usually interpreted as denoting inferiority.
Right. So they really got into how, in the area of education, just being separate in and of itself could never be equal. That the experience of being separate was detrimental to the children. What else was different about public education in the 1950s than in the 1860s when the 14th Amendment was passed? It had progressed, right? Public education was not a main responsibility of government in the 1860s. Right? I mean, there are a lot of kids that you didn't even have to go to school. But by the 1950s, educating children had really become one of the primary responsibilities of government. So that had changed. So when a court overturns a law or changes precedent, one thing they might do is look at, why was a law passed when it was passed? What was the context back then? What were they intending to do back then? And does that context even apply anymore? And so they said, when this was passed, governments we didn't even have public schools. This was not a duty and responsibility of the government to educate kids. So when they wrote the 14th Amendment, they couldn't have even contemplated the idea of how separate but equal might work in the area of public education, because it didn't even exist. So that's one way that the court justifies departing from precedent. They look at what was meant then versus the way things are now. It's a great example of that. There was another big difference between the Brown case and the Plessy versus Ferguson case. Yes, ma'am. Bingo. Plessy versus Ferguson said that separate but equal was constitutional, but that involved public transportation. And the court said, riding on a bus or a train is not the same as educating our children. So they used that as a way to differentiate, to distinguish past precedent from this case, right? Public transportation, public education, not the same thing. So just because we found that separate but equal was okay in transportation, that does not translate over to public education. So that's another reason that we're going to say that we're no longer bound by Plessy versus Ferguson. So going forward, after the Brown case, that was the law. Separate but equal is unconstitutional. And that became the precedent that was binding on future courts. It's binding today. We still hold that is unconstitutional. Any questions on Plessy versus Ferguson? All right, let me look through my questions for you to make sure that I have covered what I'm asking you on your assignment. All right, we talked about who the plaintiff and the defendant were in the original case. We talked about which party won at the trial court level. We talked about the name of the main case that was the precedent in Brown. We talked about what was previously decided in Plessy. How did, we've talked around this, but let's be direct to it. The doctrine of stare decisis, which is that courts follow precedent, follow previous decisions. How did the court treat that doctrine in Brown? How did stare decisis apply or not apply in Brown? You had to sum it up. How did the court use stare decisis? Well, it used it to distinguish between precedent so that it declined to follow precedent in this case. So stare decisis did apply in the sense that the court did have to look at precedent. It didn't follow it, but it had to give reasons why this case was different or why it was not going to follow it. So that was how it got applied. It didn't just get applied blindly, where, well, that's what we decided before, that's what we got to decide now. We talked about what had changed between the Plessy case in the 1890s and Brown in the 1950s. We talked about the court's rationale for not following Plessy. We talked about why the court decided to hear this case. We talked about the law that was at issue in the case. All right, so if I framed the question to you, the issue in the case was whether or not the separate but equal doctrine violates the 14th Amendment of the Constitution in the context of public education. That's the one sentence issue. What would you say is the one sentence holding of the case? In one sentence, what did the court decide? It's the mirror of what I just said. Somebody take a stab at that. Well, close. He said Plessy versus Ferguson violates the 14th Amendment. Yes and no, but be more specific. That's part of the decision, but be more specific to the Brown case. What did the court decide? Yes, ma'am. Boom. The separate but equal doctrine does violate the 14th Amendment to the U.S. Constitution in the context of public education. Excellent. All right, anybody have any questions on that? So by Monday night, you'll answer the new discussion question, you'll finish those 2 assignments, and then starting Tuesday morning, we'll start a new unit on a completely different topic of law. I think we're going to do contracts next. So we'll do contracts, and it'll flow the exact same as it did for this unit. All right, if you came in late, please come down and let me know. Came in after I took roll. I got you.